Criminality and politics have become twin nowadays. And recently you have heard the news about Mukhtar Ansari recently had died. So what was this special about Mukhtar Ansari? So while being in jail, he contested 3-time election and he also won. So being a aware citizen of this country, you have this question in your mind that are they allowed to contest elections? Hello everyone, welcome to the in-depth series of Drishti IAS. I am Ritu and today's session is about jailed person can contest election or they can vote in elections or not. And this session is important for GS2 perspective and also for your essay perspective and ethics perspective. So moving towards the points of discussion part. First of all, we are going to discuss the news, then we'll have a discussion about right to vote and right to be elected, whether they are the fundamental rights or statutory rights. Then we are going to discuss bar against contesting election only after conviction. So here we are going to discuss that what would be the disqualification procedure and other things. Then exceptions to disqualification. There are also exceptions to disqualification. We'll discuss this thing in detail. And then bar against the right to vote for confined person. So here we are going to discuss that what is the petitions argued about that whether any person is in jail, they have right to vote or not. And after that, we are going to discuss practice question of prelims. Before that, you have to like, share and subscribe to the Drishti IAS channel. Moving towards the news part. So you already know that Lok Sabha elections are going on and we already had done with the second phase of the elections. The other 5 phases are still pending. And on June 1st in Punjab, there is an election. In some constituency, there is an election. And there is a pro-Khalistani leader who is Amritpal Singh, who is currently in jail, has decided and showed his intention that he might contest election this time. So that's why we are discussing this topic, that whether jailed person can contest elections or not, or in the past such things have happened or not. What are about their fundamental rights? So that's why we have taken this news. So this news has been taken after the intention of Amritpal Singh. Then coming to the right to vote and the right to be elected. So first here you have to understand that what is right to vote and right to be elected. So right to vote, it means that you have to elect any representative from your constituency, and right to be elected, that you have to contest election and people will vote for you. So this is a basic thing about the right to vote and right to be elected. So first here you have to know the difference, that right to vote and right to be elected are fundamental right or not. Then answer is that they are not the fundamental rights, they are the statutory rights. And for fundamental rights, you can directly appeal to the Supreme Court, you can go to the High Court, and if High Court is not listening to you, you can also go to the Supreme Court that this is my right and this is my right to exercise my vote. But here what it happens in the right to vote and right to contest election, it is a statutory right. It means that it is already written in statute of the Constitution of India, and every citizen of this country have to obey that statute. So that's why this particular thing cannot be justiciable, and you cannot go this thing for the Supreme Court that whether we have right to vote or while in prison or something like that. So this is the basic difference about the right to vote as a statute or right to vote as a fundamental right. And in Indian Constitution, it is not a fundamental right, it is a statutory rights. So in prelims examination, maybe there will be the questions related to it. So here your confusion will be not solved. I think it's very clear that right to vote is a statutory rights and right to contest is also statutory right. So because of this thing, what we have seen that if any person is convicted against any criminal charges or against any offense, the person cannot, what you can say, contest election also, and they cannot vote also. So here there is a difference that you might have this confusion that how any leader can contest elections from the jail. So if any person is on trial or if any person is under the police custody, so in that situation they can contest election. But if they are acquitted or if they are convicted, in that situation, if they are disqualified, they cannot contest election. If there is a ban on any particular person for 6 years, in that situation they cannot contest election. So this is the thing, and this has been also judged and this has been also challenged in Supreme Court several times. For instance, 5-judge Constitution Bench in 2006 in the case Kuldeep Nair versus Union of India held that the right to vote or right to elect is a pure and simple a statutory right, and the same was held with the right to contest election. So this is about this thing. But here there is a difference, that free and fair elections, it means that this is a basic structure of Indian Constitution, and if any law will contradict with this particular right to conduct free and fair election, the law will be struck down. So this is not the basic structure of Indian Constitution, but right to conduct free and fair election is a basic structure of Indian Constitution, and no law can contradict with it. So this is the difference. Coming to the next one. Next one is about bar against contesting election only after conviction. So Section 8 of Representation of People Act 1951 is titled Disqualification Conviction for Certain Offences. And in that case, if you are a criminal and if you are listed exhaustive list of a criminals, then in that situation you cannot contest election. In that case, they will be disqualified from contesting election. And what would be the time period? So the time period is 6 years. It means that the day you are convicted till the after 6 years you cannot contest election. So this is the bar against contesting election only after conviction. So you cannot contest election when you are convicted for a particular offense or for a particular crime. Coming to the next one. The next slide is about disqualification only kicks in once a person has been convicted, and it does not apply if they have only been charged with criminal offenses. It means that if they are charged, it does not apply into that scenario. And in the case of preventive detention also, in the case of police custody also, they have right to contest election, they have right to vote also. But in the case of conviction, here you need to know the difference between conviction and charge. If any person is charged, then he or she is free, but if any person is convicted, then he or she is not free to contest election or even to the vote also. And this thing has been already challenged in the Supreme Court, and the case is still going on, that the disqualification period should be reduced and there should be not much hards. So these things are already in the Supreme Court. Coming to the next one. Next one is about exceptions to disqualification. So the Election Commission of India is empowered under Section 11 of the RP Act to remove or reduce the period of disqualification. So this right is exclusive with the Election Commission of India, and such kind of incidents has also happened. In 2019, the Sikkim Chief Minister Prem Singh Tamang has charged with what you can say misappropriating funds in the procurement of the cows, and his disqualification period is reduced for 1 year. And when he came out of the jail, he contesting the by-election, and he also won the by-election. So this was the case, and such thing had also happened. Then coming to the next one. The next one is about bar against right to vote for confined person. So if any person is convicted under any offenses, the person cannot vote. And here you may be very worrisome that why a person cannot vote. So the first difference I have already told you, and these kind of petition has been already challenged in Supreme Court, and Supreme Court has cited few reasons. The first reason I already have told you, that this is a statutory right, this is not the fundamental right. So in that situation, you cannot tell any court that this is my right and I want to contest election or I want to vote. So this is the first thing. On the other thing, Supreme Court has also highlighted few cases and few reasons that why they cannot cast their vote. The first thing is that the court reaffirmed that the right to vote was a statutory right. I have already told you. The second is that the court held that there is a resource crunch as infrastructure, because police are already deployed to the polling booths. In that situation, if you want any criminal or if you want any person who is convicted under grievous offense, in that situation you need police also, you need force also. So there is a resource crunch already, and if you want to cast these kind of person vote, then you have to also take care of the infrastructure, you have to also take care of the human power and infrastructural power. So the third is that the person is in prison, and because of their conduct, they are in the prison. In that situation, they cannot claim the equal freedom like other person, because any common person has not committed such kind of the offense. And if the person is enjoying their right to vote or right to contest election, you cannot claim the equal rights, because of your conduct, because of your offense, you are in the jail. So the third reason, it has been cited by the Supreme Court. And the fourth reason is that restrictions on prisoners' right to vote are reasonable, as it is connected in keeping persons with criminal background away from the politics. Because criminalization of politics is very much common in today's time. In that situation, these kind of restrictions are reasonable, because if the person will be out from the jail and if the person has right to vote, they may have power to influence other. And in that sense, we are promoting criminalization in the politics. So in order to reduce criminalization in the politics, or in order to remove criminalization and politics, the Supreme Court has taken such kind of decisions, and this is a very reasonable in nature. Into the eyes of Supreme Court, these all restrictions and these all reasons are reasonable for a person who is convicted under certain offense. Coming to the question is, consider the following statement about Representation of People Act. And the first statement is, this act makes provision for conduct of elections in India. And the second one is, it also talks about the qualification as well as grounds for the disqualification of MPs and MLAs. Here they are asking the correct one. We already had discussed these points. So I hope you are able to answer this in the comment section. I hope you like this session. If you have any queries related to this session, kindly ask in the comment section. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.